Good evening, and welcome to a conversation with Associate Justice Ruth Bader Ginsburg of the Supreme Court of the United States. I am pleased to thank Duke Law School and Duke DC for sponsoring this event. I ask at this time that you please silence your smartphones. My name is Neil Siegel. I am a proud Duke graduate, a former law clerk of Justice Ginsburg, and the David W. Eichel Professor of Law and Professor of Political Science at Duke, where I also direct the law school's DC Summer Institute on Law and Policy. The Institute enables students who are thinking about law school to try it before they buy it by taking short introductory law school classes taught by Duke Law faculty each summer here in the nation's capital. The Institute is in its fourth year. Over the past 2 summers, we have been hosted in very fine fashion by Jones Day, one of our nation's premier law firms. Thank you, Jones Day, for your hospitality. For the 4th year in a row now, Justice Ginsburg is giving generously of her time and her mind by joining us for a conversation about law and life. Even before becoming a judge on the DC Circuit in 1980 and a justice on the Supreme Court in 1993, Justice Ginsburg earned a prominent place in history by persuading those in positions of power to honor a truth that ought to have been self-evident, but historically has not been, that women and girls, too, are created equal and are part of the people in whose name the Constitution purports to speak. Her work as a justice, including in recent terms where she has written some of the most important opinions of her career, has reflected her commitment to ensuring the equal citizenship stature of people who long did not count or did not count nearly enough in constituting we the people. Justice, welcome, and thank you once again for making this evening possible. We look forward to hearing your thoughts on the court's October 2015 term.
Good evening. I will open these remarks with a remembrance of my dear colleague, Justice Antonin Scalia. His death was by far the most momentous occurrence of the term, and his absence will be felt for many terms to follow. There's a play called The Originalist. It is about Justice Scalia and a fictional law clerk. And it opens with 2 quotations. First, the fixed meaning canon. Words must be given the meaning they had when the legal text was adopted. And second, such is the character of human language that no word conveys to the mind in all situations one single definite idea. The first quotation is attributed to Justice Scalia and Brian Garner in their book, Reading Law, The Interpretation of Legal Texts. The second was penned by the great Chief Justice John Marshall. Justice Scalia would no doubt stand by the words he and his co-author wrote. My view accords with the great Chief Justices, and I believe Justice Scalia would agree that Marshall had a point, that no word conveys to the mind in all situations one single definite idea. I will not discuss with you Justice Scalia's provocative jurisprudence. I will speak instead of our enduring friendship from the years we served together on the U.S. Court of Appeals for the D.C. Circuit through the nearly 23 years we were 2 of the 9 justices on the U.S. Supreme Court. In a preface to the libretto for Derek Wang's comic opera, Scalia-Ginsburg, Justice Scalia described a high point of his days on the bench. It was a spring 2009 evening at the Opera Ball held at the British ambassador's residence. In an elegant, spacious room with very good acoustics, Justice Scalia joined two regular Washington National Opera tenors at the piano for a medley of songs. He called it the famous Three Tenors performance. Both on and off the bench, Justice Scalia was an exuberant performer. It was my great good fortune to have known him as a constantly stimulating working colleague and a cherished friend. Among my store of memories, an early June morning in 1996, I was about to leave the court to attend my circuit's judicial conference at Lake George. Justice Scalia entered my space in chambers, opinion draft in hand. Tossing a sheaf of papers onto my desk, he said, "Ruth, this is the penultimate draft of my dissent in the Virginia Military Institute case. In the VMI case, there was only one dissenter, that was Justice Scalia. I will acknowledge that Justice Thomas was recused because his son was attending VMI at the time. As he put the papers on my desk, Justice Scalia said, "This is the penultimate draft. It's not yet in shape to circulate to the court, but the clock is running out, and I want to give you as much time as I can to answer it." I read the dissent on the plane to Albany. It was a zinger. It took me to task on things large and small. Among the many disdainful footnotes, the court refers to the Charlottesville campus of the University of Virginia. Unlike university systems with which the court is perhaps more familiar, such as those in New York, my home state, there is only one University of Virginia. Thinking about fittingly restrained responses consumed my weekend, but I was glad to have the extra days to adjust the court's opinion. My final draft was more persuasive thanks to Justice Scalia's searing criticism. Indeed, whenever I wrote for the court and received a Scalia dissent, the majority opinion ultimately released was clearer and more convincing than my initial circulation. Justice Scalia homed in on the soft spots and energized me to strengthen the court's decision. Another indelible memory, December 12, 2000, the day the court announced its decision in Bush v. Gore. I was in chambers, exhausted after the marathon. Review granted Saturday, briefs filed on Sunday, oral argument Monday, opinions completed and released on Tuesday. No surprise, Justice Scalia and I were on opposite sides. The court did the right thing, he had no doubt. I strongly disagreed and explained why in a dissenting opinion. Around 9 p.m., the night the opinions were released, the telephone rang, my direct line in chambers. It was Justice Scalia. He didn't say, as he often did, "Get over it." Instead, he asked, "Ruth, why are you still at the court? Go home and take a hot bath." Good advice I promptly followed. Among my favorite Scalia stories, when President Clinton was mulling over his first nomination to the Supreme Court, Justice Scalia was asked by an interviewer, If you were stranded on a desert island with your new court colleague, who would you prefer, Larry Tribe or Mario Cuomo? Scalia answered quickly and distinctly, Ruth Bader Ginsburg. Within days, the president chose me. I recall, too, a dark day for me. I was confined in a hospital in Heraklion, Crete, in the summer of 1999, the beginning of my long bout with colorectal cancer. What brought me to Crete? Justice Scalia's recommendation that I follow him as a teacher in the Tulane Law School's summer program there. The first outside call I received was from Justice Scalia. Ruth, he said, I am responsible for your days in Crete, so you must get well. And is there anything I can do to help? Justice Scalia was a man of many talents, a jurist of captivating brilliance, high spirits, and quick wit, possessed of a rare talent for making even the most somber judge smile. The press wrote of his energetic fervor, his astringent intellect, peppery prose, acumen, and affability. Not so well known, he was a discerning shopper. When we were in Agra together in 1994 for a judicial exchange with members of India's Supreme Court, our driver took us to his friend's carpet shop. One rug after another was thrown on the floor, leaving me without a clue which to choose. Justice Scalia pointed to one he thought his wife Maureen would like for their beach house in North Carolina. I picked the same design in a different color. It has worn very well. Once asked, how could we be friends given our disagreement on lots of things? Justice Scalia answered, I attack ideas. I don't attack people. Some very good people have some very bad ideas. And if you can't separate the two, you got to get another day job. You don't want to be a judge, at least not a judge on a multi-member panel. Example in point, from his very first days on the court, Justice Scalia had great affection for Justice Brennan, and Justice Brennan was drawn to Justice Scalia. I miss the challenges and the laughter Justice Scalia provoked, his pungent, eminently quotable opinions, so clearly stated that his words rarely slipped from the reader's grasp, the roses he brought me on my birthday, the chance to appear with him once more as supernumeraries at the Washington National Opera. The court is a paler place without him. Toward the end of the opera, Scalia Ginsburg, which, by the way, will have its second performance next summer in Cooperstown, New York, at the Glimmerglass Opera Festival. Toward the end of the opera, we sing a duet. We are different, we are one. Different in our interpretation of written texts, one in our respect and affection for each other, and above all, our reverence for the Constitution and the court. I will next give you a rapid review of the term's decisions, but I'll start with a numerical snapshot. From June 2015 to May 2016, the court received about 6,400 petitions for review, down from 6,500 in the previous term. From those thousands of petitions, we selected only 67 for full briefing and argument, not counting the one petition we dismissed as improvidently granted. To the 67, the same number that we decided last term, add 12 per curiam decisions that is, opinions rendered without full briefing or oral argument, just on the basis of the petition for review and the brief in opposition. So adding those 12, that brings the total opinion production to 79. There were records set during the term. According to a law professor who keeps tabs on these things and then blogs about them, Justice Breyer asked the longest question at oral argument. In United States v. Texas, a challenge to the president's deferred action immigration policy, Breyer's inquiry ran 52 transcript lines. In total questions asked, however, Justice Breyer ranked only 4th, asking 381 questions. He stood behind Justice Alito, whose questions numbered 401, and the Chief Justice, who questioned counsel 417 times. Far out in front, with 477 questions, Justice Sotomayor replaced Justice Scalia as the justice who asked the most questions at oral argument. Justice Thomas, after a 10-year silence, astonished all in attendance by asking 9 questions, all in the same case, Voisin against United States. The issue that sparked his interest, whether a misdemeanor assault conviction for reckless conduct triggers a statutory ban on possessing firearms contained in 18 U.S.C. 922G. With all returns in, the court completed the term's work on June 27th. We divided 5-3 or 4-3 in only 8 of the 67 argued cases. We were unanimous, at least as to the bottom line judgment, in 25 cases. So we agree much more than we disagree. And in 4 cases, we affirmed judgments of the courts of appeals by an equally divided court. When the court is evenly divided, no opinions are released, and the automatic affirmance of the court below has no precedential value, and even division is essentially the same thing as a denial of review. 3 of the 4-4 automatic affirmances were among the term's most closely watched cases. I will try a capsule description of each. First of the 4-4 splits, Friedreich against California Teachers Association. The petitioners in that case asked the court to overrule a decision in Abood against Detroit Board of Education and hold that requiring public sector employees to pay anything to a union violates the First Amendment's free speech guarantee. Abood, the precedent, held that all workers could be required to contribute to the cost of collective bargaining and union-operated grievance procedures. That is, things for which all employees benefit. They were not required to pay for any of the union's political activities, but they were not permitted to free ride on collective bargaining and grievance procedures. So that decision stands for the nonce until the court numbers 9. On June 23rd, 4 days before we finished, the court reported equal divisions in Dollar General against Mississippi Band of Choctaw Indians and United States against Texas. In Dollar General, the issue was whether a tribal court can hear civil claims filed by members of a tribe against non-members who engage in wrongful conduct on Indian reservation. It is the first statute in which Congress has permitted a tribal court to hear a case against a non-Indian. In the United States against Texas, a number of states joined together to challenge the legality of President Obama's policy of deferring deportation of some 4 million unlawfully present aliens whose children are U.S. citizens or lawful permanent residents. Under longstanding government policy, aliens granted deferred action are eligible to receive certain benefits, prime among them permission to work legally in the United States. A divided Fifth Circuit panel enjoined implementation of that policy. United States v. Texas came to us at a preliminary injunction stage, and that means the case will now return to the trial court for a likely full airing on Texas's request for a permanent injunction against the president's policy. So chances are the case will be back in our court after round 2 in the district court and the Court of Appeals. We resolved another headline case on May 16 without any opinion on the merits. Zubik against Burwell, and the case is consolidated with it, involved objections by religious nonprofits to providing contraceptive services coverage in their employees' health plans, as required by the Affordable Care Act. The litigation was based primarily not on the First Amendment's free exercise clause, but on a law passed by Congress called the Religious Freedom Restoration Act. Attempting to accommodate the nonprofits' objections, the government had called upon third parties, mainly insurers, to provide the contraceptive coverage in the religious employer's stead. Even that accommodation, the nonprofits asserted, burdened the exercise of their religious beliefs because it made use of their health plans. After hearing argument, the court requested supplemental briefing to determine whether the parties might compose their differences. The additional briefs in hand, the court issued a per curiam order remanding the case so that the Court of Appeals could consider what the new briefs conveyed. Justice Sotomayor filed a concurring opinion, which I joined, emphasizing that the court's order in no way tipped the scales in the nonprofit's direction on the merits. I will describe now some of the terms headline cases that yielded dispositive rulings. Evenwell v. Abbott concerned who counts under the one person, one vote principle derived from the 14th Amendment's Equal Protection Clause. In drawing state and local legislative districts, should a state count only those eligible to vote, as the plaintiffs, Texas voters, urged, or does everyone, the district's total population, count? We held that jurisdictions may draw legislative districts to equalize total population. I think you appreciate what an enormous difference that makes in Texas. The framers of the 14th Amendment, we emphasize, selected total population as the basis for congressional apportionment. They wrote, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state. It cannot be, I wrote for the court, that the 14th Amendment calls for the apportionment of congressional districts on the basis of total population, but simultaneously prohibits states from apportioning their own legislative districts on that same basis. High on the terms list of leading decisions, Fisher against University of Texas at Austin. It is a case that returned to us for a second time the question, does the university's affirmative action admissions policy meet the court's equal protection measurement? When the Fifth Circuit invalidated the university's initial plan, the Texas legislature adopted a top 10% plan under which all Texas students who graduate in the top 10% of their high school classes gain admission to the University of Texas. And that plan accounts for some 75% of the entering class. To complete the class, the university considers a number of factors, one of them a student's race. Last time we had the Fisher case in 2012, the court sent the case back to the Fifth Circuit, the court that had determined that the policy was valid. And the court sent it back for the Court of Appeals to consider whether it had applied with sufficient rigor the strict scrutiny that attends all review of race-based classifications. I dissented that time on the ground that the university had followed assiduously the holistic race-conscious model the court had approved in Ruth against Bollinger, the University of Michigan Law School affirmative action case. Like Michigan's law school, the University of Texas used race as only one factor among many. The top 10% plan, which the majority regarded as race neutral, I suggested, could not fairly bear that description, for it was adopted and worked only because of the state's racially segregated neighborhoods and schools. Well, when we sent the case back, the Fifth Circuit again upheld the university's admissions policy, and this time, in a 4-3 decision written by Justice Kennedy and announced on June 23rd, the court affirmed the Court of Appeals judgment. Justice Kennedy wrote for the majority. Though a college must continually reassess its need for race-conscious review, here that assessment appears to have been done with care, and a reasonable determination was made that the university had not yet achieved its goals. Public universities, like the states themselves, the court's opinion stated, can serve as laboratories for experimentation. The University of Texas has a special opportunity to learn and to teach. Rivaling Fisher, the affirmative action case, at the top of the most watched list was Whole Women's Health against Hellerstedt. In that controversy, Texas abortion providers challenged the constitutionality of two severely restrictive abortion access regulations imposed by the state's legislature. First, a requirement that abortion clinic physicians obtain admitting privileges at local hospitals. And second, a mandate that clinics meet minimum standards required of ambulatory surgical centers. If the law had become fully operative, the district court found, only 7 or 8 contraception and abortion clinics out of some 40 would remain. The Fifth Circuit upheld the Texas restrictions in principal part. On the term's last opinion day, June 27, we reversed 5-3 in an opinion by Justice Breyer. The Texas requirements did not genuinely protect women's health, the court observed. Instead, they burdened a woman's access to an abortion for no acceptable reason. In a concurring opinion, I emphasized that Texas trained its restrictions on abortion providers alone and placed no such restrictions on medical procedures considerably more dangerous to patients, including tonsillectomies, colonoscopies, and childbirth. There were two cases that were closely watched abroad. One, RJR Nabisco against European Community, the other, Bank Marchese v. Peterson. In RJR Nabisco, the European Union invoked our Racketeer Influenced and Corrupt Organizations Act, commonly known as RICO, to sue a corporation organized and headquarters in the United States for allegedly orchestrating a complex global money laundering scheme. The European Union asserted losses sustained by European financial institutions and by member states lost opportunities to collect duties. The court ordered dismissal of the European Union suit. It held that absent a domestic injury inside the United States, private civil actions could not be maintained under RICO. No such limitations, the court held, apply when the government, rather than another entity, when the government brings a civil action under RICO. I dissented, joined by Justices Breyer and Kagan, on the ground that the domestic injury requirement invoked by the court to stop the lawsuit, that requirement was nowhere prescribed in the statute. It was the court's own invention. Bank Marchese involved the constitutionality of a provision of the 2012 Iran Threat Reduction and Syria Human Rights Act. The provision identified a set of assets held at a New York bank for Bank Marchese, the central bank of Iran. It made those assets available to satisfy some 16 district court judgments against Iran for its part in terrorist attacks abroad that took the lives of many U.S. citizens. The cases were consolidated for post-judgment execution in a proceeding, the statute named by docket number. The question presented, did the provision violate the separation of powers by directing a particular result in a pending case? In an opinion I wrote, the court upheld the statute and thus freed the assets for distribution among the plaintiffs. Congress, we reaffirm, cannot tell a court how a case should be decided under existing law, but it can, in many cases, amend the law applicable to a pending case, even when the amendment will determine the outcome in that case. The decision drew a strong dissent from the Chief Justice, joined only by Justice Sotomayor, and an irate response from Iran, including a suit against the United States filed by Iran in the International Court of Justice at The Hague. And finally, I cannot resist reporting the term's most memorable slip by an attorney. On April 27, the last day for oral argument, an advocate responded to my question. There are lots of other statutes that would prohibit precisely what you are suggesting, Justice O'Connor. I gently reminded counsel, that hasn't happened in quite some time. The first woman on the Supreme Court retired a decade ago, yet confusion of the two of us lingers. The number 8, as the terms 4-4 splits show, is not a good number for a multi-member court. When the 2016 to 2017 term ends, I anticipate reporting on decisions rendered by a full bench. And that's my quick survey of the term just passed, and now I look forward to a conversation with my dear and former law clerk, Professor Neil Seal.
Well, thank you, Justice. And thank you for your opening remarks about Justice Scalia. He was a friend to Duke Law School. He visited our students in Durham, and he also taught in our Duke in Geneva program 5 or 6 years ago, and it had been a good term for him. He was in a great mood. It was the term before the first healthcare case. And he taught a separation of powers class, and I was there to help him, which mostly meant answer his questions, disagree with him, and most importantly, grade his exams. And on the last day of the class, he gave what scholars have come to think of as his originalism stump speech, which I'm sure you've heard versions of on and off the bench, that you're either an originalist or you're making stuff up. And then he asked if there were any law professors in the room who cared to disagree with him, and I was the only law professor in the room at the time. And instead of explaining why originalism is normatively unattractive or descriptively inaccurate, I discovered over the course of those weeks that I could criticize him gently in the form of a compliment. And so I said, Justice, yeah, you're an originalist in this case and that case, but you're too sensible to be just an originalist. You remember that case in which you were a structuralist? Remember that case in which you were a traditionalist? You remember all those cases in which you were a doctrinalist? You said, I'm an originalist, I'm not a nut. And then you have to decide when you're going to be what, so you're also a prudentialist. You're exercising discretion in the present. And he sighed and thought for a moment and said, maybe I need a better word for what I am. And I said, how about a judge? And he laughed and went back to his originalism stump speech. So I ask you, was I being unfair? Was he an originalist, or was he a judge who may have used originalist techniques more often than some other judges?
I think I already answered that question, Neil, when I said I think Justice Scalia would agree with Justice Marshall, Justice John Marshall's wisdom when he said words have no fixed, definite meaning in all settings.
Mm-hmm. Yeah, okay. Well, it seemed like, just for the record, my students in the DC Summer Institute read McCulloch against Maryland, which is the case
yes,
from which
that's
that
the
quote,
case. That comes from.
That quote
Yes.
derives. So many people, as you mentioned, have wondered about your relationship with Justice Scalia and professional disagreements, personal deep friendship. And it seems like this term really brought that potential tension to bear, because if Justice Scalia gets to record his vote, it ends up looking like a very different term. Fisher is 4-4 instead of your being in the majority. Friedrich's is a 5-4, right? Loss for the unions. U.S. against Texas is almost certainly a 5-4 loss for the administration. And I'm just wondering, you're obviously aware of that. What do you do with that knowledge or information?
You're right about Friedrich's. You're right about the potential overruling of Abood. Mm-hmm. But the affirmative action case would have come out the same way, because if we split 4-4, Fifth Circuit decision is automatically affirmed, and the Fifth Circuit had upheld the Texas plan.
Right, but there's a difference, of course, between setting no precedent and setting an important precedent.
Yes, but isn't it good that we were able to set a precedent so universities can relax? Mm-hmm. I mean, we were getting the Michigan case, Texas case. Now this decision goes back to Justice Powell's view of affirmative action, permissible if it is only one factor among many. And so I think that most university presidents must have breathed a great sigh of relief that it was not a guessing game anymore. And so that was the 4-3. By the way, Justice Kagan was recused. So I think if Justice Kagan were not recused,
Right.
it would have been 5. It would have been 5-4. So.
Let me ask you a question about the Zubik case, the contraceptive coverage case. And it's not a particularly nice question for the court, but it is a question many scholars have been wondering about, which is whether it's really the role of the Supreme Court to suggest to parties that they settle by the time a case gets to the Supreme Court, or is that really not an appropriate way to proceed?
In general, I agree with you. In this particular case, what would have been better? No decision at all, a 4-4 split, or a return to the Court of Appeals to consider whether the parties had narrowed their differences. And agreement among the parties is always something to cheer. So we shall see.
Right.
What ultimately happens, whether both sides will concede something and come up with a solution both can live with.
Do you think there's ever circumstances in which a 4-4 split should be accompanied by an explanation, an opinion of some fashion? I'm thinking about U.S. against Texas, which sets no precedent but has potentially dramatic consequences for as many as 5 million people, and we really don't know anything about the reasoning of both sides on the court. I realize the concerns.
Right.
I realize the concerns about advisory opinions, but was there a standing issue? Was it the Administrative Procedures Act? Was it immigration law? Was it the Take Care Clause? Right? We get no explanation, and yet this non-decision causes real effects in the world.
Because the issue will come back to us again. And it is much better that when it comes back to us, we haven't given a preview of how we would decide the case. A 4-4 split means the court can't issue a judgment.
Right.
And as I said, it is the same as if we had denied review. Then the lower court opinion stands, and we have no part in it. But in both cases, the Friedrich's case and the president's immigration policy, those are almost certain to come back to the court again. And it's better that we hear and decide on a clean slate with no one having previewed his or her views.
Could you, to the extent it's appropriate, could you say a little more about life work as a justice on an 8-justice court that runs a non-trivial risk of 4-4 splits?
Yeah. I think the court did very well in having only 4 decisions come out with a 4-4 split. An even number is not good for a collegial court.
Yeah, the first Judiciary Act tried it. There were 6 justices, and then that was quickly changed.
Yes.
Yeah, and it's been set at 9 since 1869. Right, 9. Would you agree that 9 is a good number?
I certainly wouldn't want any more.
Would you want fewer? Would you want 7?
Well, when I was on the D.C. Circuit at the Court of Appeals, which I was for 13 years, all I had to do was persuade one other mind. Here, 4 people have to agree with me.
Yeah. Okay, so we should have a 3-justice
No.
Supreme Court and a lot more work for each.
But you know, many Supreme Courts in the world do divide up into panels. Even the newly created Supreme Court of the UK, they sit in panels of 5. There are 15 altogether. And in special cases, they may have a larger panel, but the standard is five members. The Supreme Court does everything together. There's nothing that we divide up into panels to do.
Are there any advantages to an 8-justice court? And I'm not pleading for an 8-justice court by any means, but in terms of trying to come to some kind of agreement or consensus, not simply counting to 5 and being done with the case?
With 9, we are still trying to persuade each other. I mean, the vote at conference is a tentative vote. For a dissenter, hope springs eternal. You hope that your dissent will be so persuasive that you will capture 1 or 2 more votes and turn the dissent into a majority opinion. That is a rare occurrence, but it happens. A dramatic illustration is a case I was assigned by my senior colleague some years ago to write a dissent, just with the 2 of us. In the fullness of time, the decision came down 6-3, but what started out as 2 grew to 6, and only 3 remained on the other side. Every time I'm on the dissent side, I'm hoping for another such experience. Hasn't happened, yes, but I remain hopeful.
Well, I remember a less dramatic incident in which one of your law clerks was working with you on a dissent for 4 justices, and it ended up being a 5-justice majority opinion. That was, well, it was more of a highlight for me than it was for you. So, you've been on the court for 23 years now.
Hard to believe.
All right, 23 years. How has it changed? And if so, how has it changed?
It was a major change when Justice O'Connor left us. I mean, to be blunt, that year, every time we divided 5-4, and I was with 4, I would have been with 5 if she had remained on the court.
That's 2006.
Yeah.
And what about the court's relationship to American society? Has that changed, in your estimation, in any discernible way over the past 2+ decades?
I think, Neil, that's a question more appropriate for you, who you're a consumer of the court's product. And so let's turn the table. I'll ask you that question.
Yeah. So now you're a therapist. Well, I thought you would be proud. Look at how many people came to hear me speak tonight. I would agree that the court changed and changed significantly in 2006, and with respect to many issues, I think there are some prominent exceptions, like gay rights, in which the court moved in a more progressive direction. But I saw a court that, in fact, the political scientists who study this can see, right, a very large ideological distance between where Justice O'Connor was and where Justice Alito has been. And so I would agree that that's a significant inflection point in the court's past over the last 2+ decades.
Are you including this term just passed?
Well, that's where I'm going next, right? Which is that I think that was the trend until recently. I would say the last couple of terms.
I think that this term the Fisher case, which had come out the other way, the whole women's health case.
Yeah. Obergefell, right, King against Burwell, the term before. So I think there has been a significant change recently, I think in part because of Justice Scalia's untimely passing, and in part because one of your colleagues may have moved in a non-trivial way. So that's how I would in a rough and ready way size it up. I think we're
Well, the colleague you have in mind is Justice Kennedy.
yes.
And you mentioned Obergefell, the gay marriage case. Every one of the cases that involve treating gay and lesbian people decently,
Yes.
every one of them was written by Justice Kennedy.
Yeah, I'm thinking more about not whole women's health, which I didn't think was a surprise at all, but I'm thinking about his vote and opinion in Fisher too, which was, I think, a surprise to myself and to many people who watched the courts closely.
You say that about whole women's health, even though we had the so-called partial birth abortion?
Yeah, because I think he viewed, this was Gonzalez against Carhart in 2007, in which the court, in an opinion by Justice Kennedy, upheld the Federal Partial Birth Abortion Ban Act of 2003. And in my introduction, I mentioned some of the most important opinions of Justice Ginsburg's career. I would include your dissent in that case. Yeah, I think I understood him to view that as an issue about that certain controversial method of abortion. And I combined his vote there with his passionate dissent in Stenberg against Carhart in 2000, dealing with the Nebraska law. It's very interesting if you contrast the politics of opponents of abortion, which I think tried to use the partial birth issue as a way of persuading people that abortion writ large is immoral as well as within constitutional bounds to regulate. But his opinion for the court actually distinguished that one procedure from the most typical method of second trimester pre-viability abortion. And so he almost used law to push back. And so I always thought of whole women's health as a case about whether Casey stands for anything anymore.
And it does.
And it does. I mean, and it unambiguously does. And in fact, that leads me to another question. I thought, I think the court.
Does everybody know what Casey was?
Do you want to?
No, you can.
Planned Parenthood against Casey is the court's 1992 decision in which it reaffirmed the core of the abortion right that the court articulated in Roe against Wade in 1973, but also allowed greater regulation of abortion than had previously been permitted under Roe. The court replaced the strict scrutiny standard, the most demanding form of judicial review, with the undue burden standard. And so if states can simply relabel an interest in protecting fetal life by banning abortion an interest in protecting women's health, and courts are simply to defer to a legislature's finding that a restriction, no matter how medically unnecessary, will protect women's health, then there is nothing left of Casey, or very little left of Casey, it seems to me. And I think the court emphatically rejected the view of Texas that you can simply say that a restriction is protecting women's health, notwithstanding a complete lack of evidence that it does. Now, you wrote separately, and you rarely write separately. You're not a justice who feels the need to constantly express herself. And so I'm wondering why, in Whole Women's Health, you felt moved to write a separate short concurring opinion.
So that the public and the press could get it all in a nutshell. Justice Breyer's excellent opinion goes through all the arguments made on behalf of Texas, one by one by one. It's a very long opinion. And it was necessary to do that. But I wanted to summarize in one paragraph what the court did. And also to make the obvious point that the women who felt the effect of the Texas law were not well-heeled women. It was only the most disadvantaged women, poor women, that these access barriers stopped and might drive them to what the situation was before, when there were back alley coat hanger abortions.
So the court, in its holding, determined that there was an unconstitutional effect, that the law had the effect of imposing a substantial obstacle in the path of a pregnant woman who seeks to abort a fetus before viability. The court did not hold that there was a constitutionally impermissible purpose. And yet, Justice Breyer, in his majority opinion, conducted the exact inquiry one would conduct to smoke out an impermissible purpose, namely that the restriction is so over and under-inclusive with respect to its stated objective of protecting women's health that the law doesn't advance that objective. And I understand the desire on the part of judges to avoid being unnecessarily divisive or controversial and calling out a legislature for having acted for a bad purpose. But given how transparently impermissible the purpose was, I'm wondering why the court did not do that. And you came close in your separate opinion, but you did not, I don't think, really do that expressly as well. And I'm wondering if you could share your explanation for not doing so.
The court went through all the reasons why this legislation was not protective of a woman's health. And then the reader could draw his or her own conclusions as to why would a state legislature enact a law that had those bad effects. Justice Breyer pointed out, among many things, these clinics, the favored method of abortion was the medical abortion. Mm-hmm. So you take pills in the clinic, and then you go home. The requirement that the doctor have privileges at a hospital 30 miles from the abortion clinic made no sense. Mm-hmm. Because if you were really serious about the woman, you'd say it had to be 30 miles from where she lived, not from where the abortion clinic was. But there was so many irrationalities.
Yeah, I mean, my favorite feature of the case was Texas's argument that it wasn't problematic that all women in Texas, in the vast area of the state west of San Antonio, wouldn't have access to a Texas clinic without driving hundreds of miles because they could simply go across the border to New Mexico. And Texas has no control over how abortion is practiced in New Mexico, right? So how can a state that is arguing that we're trying to protect women's health, how are they not stopped from making that kind of an argument? And I never really understood. Well, I think I did understand, right, that there really isn't an answer to that objection. Let me switch gears, if I may. Are you proudest of the work that you did before you became a judge, or the work that you've done since becoming a judge?
I had a fantastic opportunity for 10 years of my life. That is, society, for the first time in the history of the country, was ready to turn in a new direction with regard to women's choices of what their life would be. The generation before mine, there were people, men as well as women, saying the same thing, that daughters should have the same opportunities. to aspire and to achieve, to develop their own talents and capacities, and should not be held back by artificial law-imposed barriers. That was the message that in the decade of the 70s, everyone was ready to listen to. I've often made a comparison between the, quote, liberal Warren Court that said it was okay not to put women on the jury rolls, and the, quote, conservative Berger Court that declared one law after another unconstitutional for discriminating arbitrarily on the basis of gender. You know, the court doesn't follow the daily headlines, but a great legal scholar, Paul Freund, said, court should never be influenced by the climate of the day, but by the climate of the era. Inevitably, the court will be influenced. And the legislatures, both state and Congress, were changing these gender-based laws. I mean, one of the projects in which I was engaged at the request of the U.S. Civil Rights Commission was to go through all the U.S. code and identify the gender-based differentials. I mean, and Congress changed most of those laws, as did the state legislatures. So I was really riding on a wave. Mm-hmm. And it was just, I consider myself fantastically fortunate that I was in a position to be part of that enormous change. I mean, you teach in the law school, Neil. Think of when I started teaching at Rutgers Law School in New Jersey. My first civil procedure class had 100 students, 3 were women. So women were about 3% of the law students across the country. Now they're about 50%. And people ask me, did you always want to be a Supreme Court justice? Women of my vintage, we wanted to get a job in the law, any job, as long as it was as a lawyer and not as a secretary. Mm-hmm. You know the story of Justice O'Connor's first job. So she was very high in her class at Stanford, but no one would hire her as a lawyer. So she went to a county attorney and said, I'll work free for 4 months. And then, if you think I'm worth it, you can put me on the payroll. And of course, she was by far the best person in the office, and they put her on the payroll. That was the challenge for my generation. Getting the first job. If you got the job, you generally did it better than the men. So the second job was not so hard, but the first one really was. Then those were the days when there was no Title VII, so employers could be upfront and say, we don't want any lady lawyers in this shop. But so I think, people give me much more credit than I deserve for what happened in the 70s. What happened was that society was ready to move in a new direction. And then the court, which rarely leads, it was following the change that had already occurred in society. I think another example of that is my children are 10 years apart. So when my daughter, who was born in 1955, when she started school, there were not many mothers who worked. In fact, Jane said she was invited to sleepovers and after school because the parents of her classmates felt so sorry for her because her mother was working. My daughter had a much different idea when she was asked did she want to have mommy around the house more. She said, oh, no, please no. But 10 years later, 1965, when my son was born, it was not at all unusual to have two in families. So the society had changed, and the law was catching up to that, to that change.
So where do you think America is today with respect to treating women as full and equal citizens? You know my daughters, Sydney and Dylan, they're great fans of yours. And they are constantly pointing out to me how gendered American society continues to be. And they're 11 and 9. It's mostly Sydney. Why have we not had a woman president? How many female justices have we had? I tell them. And they say, why so few? Why are women's sports not taken nearly as seriously as men's sports? So I mean, where do you think we're at, and what will it take to root out conscious and unconscious bias against women?
Well, you should tell Sydney and Dylan, compared to what? Compared to the way it was. I think women are now something over 25% of the federal judges.
Mm-hmm.
I think well over 25%, maybe closer to 35%. When I graduated from law school, there had been only one woman in the history of the country ever to serve on a federal court of appeals. That was Florence Allen on the Sixth Circuit. She retired in 1959, and then there were none again on the courts of appeals till 1968, when President Johnson appointed Shirley Hofstetler to the Ninth Circuit. So you can compare the way it was not so long ago. When I think of some of the cases, you mentioned sports. One of the early cases was a girl who was by far the best tennis player in her school. And the school would permit her to play only on the girls' tennis team, which didn't have any intercollegiate contests. So I thought, gee, we ought to be able to settle this without making a federal case. But the federal case was started, the school district capitulated, and today, Title IX has done wonders for girls' sports, I think. So, yes, we haven't reached nirvana, but we have come a very long way from what I call the separate spheres. It's exemplified by the poem, What Are Little Girls Made Of? What is it? Sugar and spice and everything nice. And little boys, snails and nails and puppy dogs' tails.
What did your mother or your father teach you?
Oh, my mother taught me. My mother died when I was 17, so I wish I had had her longer. She was strict in wanting me to perform up to my ability, but and this was unusual for parents at that time, she stressed, be independent. I think she must have hoped someday I'd meet Prince Charming and live happily ever after, but that was very important to have. Two things: be independent and be a lady. And be a lady meant never to get bogged down by emotions that do you no good, like anger or jealousy. remorse, things that just drain your energy and do nothing positive. So those are very good things to teach a daughter.
Yeah.
Also, she made reading a tremendous pleasure for me because I remember my earliest memories of sitting on her lap and she was reading to me. So, and then she would take me to an excursion to the library once a week. She would get her hair done while I was in the children's section picking out my 5 books that I take home and then return the next week.
Do you have any advice for students here tonight who are thinking about law school, or students who are in law school thinking about what kind of legal career they want to fashion for themselves, or young graduates of Duke Law School heading out into the world of work?
Well, I'm very high on being a lawyer, and I've loved everything I've done in the law. But one thing I would say, that if you get a job as a lawyer and do nothing but a day's work for a day's pay, then you're like a plumber. You have an expertise. But if you are a true professional, you will realize that lawyers have a monopoly, maybe too much of a monopoly in the United States on legal services. So you owe it to your community to give back. As Justice Hugo Black put it, if you want to live a fulfilled life, you have to do something outside yourself. Whatever your passion is, whether it's the environment, discrimination, work for something outside yourself. So I think of all the years when I was heading the ACLU Women's Rights Project. I wasn't getting paid for it, but I got much more satisfaction out of doing that than the jobs I was paid for.
Well, thank you, Justice. That seems to me to be an appropriate place to end our conversation. But the Justice has agreed to stick around and meet all of you until she has to leave at 8:30. My only request is please no selfies when you do meet and talk with her. But please do join me in thanking Justice Ginsburg.